Okay, hello everybody. I'm Melissa Landau Steinman. Thank you for joining us for our monthly Venable Ad Law webinar, Gift Cards and Loyalty Programs, Balancing the Legal Risks and Rewards. I'm joined here today by Brian Tengel, who is counsel in our privacy group, and Jay Prapaisilp, I'm sorry, Jay, who is an associate in our ad law group with me. We have the rare pleasure here that we have all three of us are homegrown Venable attorneys. So I just wanted to call that out. It's a nice thing about Venable. So today we are going to talk about all things loyalty programs, all the issues, maybe, yeah, thank you, Jay. All the things that can come up in this fairly complicated area, whether it's the banking laws, things like the Card Act, at the federal level, state gift card laws and how they may interact with the loyalty programs, new laws in the area of state loyalty programs, anti-scam laws, and fraud issues when it comes to loyalty, unclaimed property and escheat, and then privacy considerations for loyalty programs. There have been a lot of new developments in this area, both in the area of loyalty and gift card in the past year or two. So it's a really interesting area, and so let's get on with it. Okay, talking about loyalty and reward programs, a little history first. Loyalty programs, of course, we all know they've been popular for a long time, but they've actually been around for hundreds of years. I didn't even know this until I did a little research going back as far as ancient Egypt. So this is according to this research we did. In 1793, a New Hampshire merchant began rewarding customers with copper tokens you could accumulate and then use for future purchases, which would then, of course, generate repeat purchases, like everybody hopes, with loyalty programs. This idea was then quickly replicated. I think the most well-known of the older forms of loyalty programs are the SNH green stamps, where people would accumulate books of these stamps, which they would then collect and exchange for rewards. These lasted up through sort of the mid to late 20th century. And then we saw the first airline loyalty program, where the airlines started to launch their currency-based or points-based, miles-based frequent flyer programs where members would join up and then earn miles based on how far they had flown or how many times they had flown, depending on the structure of the program. Then we saw the hotel program similarly launch. Holiday Inn was the first program there. Banks and retailers followed, and now today the everybody and it seems like their uncle has a loyalty program. According to a 2024 report from Fortune, the global loyalty market is projected to grow from $13.31 billion in 2024 all the way to $41.21 billion, huge jump in 2032. Next slide. Loyalty programs are regulated under a variety of different laws. They are, of course, regulated under the consumer protection laws. You have to make sure that your terms are clear, they're not misleading or deceptive, they must be disclosed clearly and conspicuously, and probably most important, and this has been coming up a lot lately, that if you make changes to your program, that you are giving proper notice. And while it for a long time was essentially, gee, this is all a matter of contract, what do your terms and conditions say in terms of your ability to make changes, and what kind of notice you'll give. Most recently, there have been a number of cases and then now laws that are finding that, gee, you do have to give proper notice. Your terms and conditions have to talk about the notice you're giving, and you can't just expire without any kind of notice to consumers, giving them an opportunity to use their points. As we'll talk about specifically in the context of credit card programs, there are some new laws. But there also has been litigation for some years where, say, most recently, an airline was sued for expiring points without notice. That Circa Resort Group was recently sued for reducing earned comps in a rewards program with charging fees for redemption, adding these terms, charging taxes. And the NAD recently found in a case against Pier 1 involving a paid loyalty program where the payment, the $9.99 a month payment or fee, was automatically added to consumers' carts with a pre-check checkbox. And then Pier 1 advertised that a 10% discount was available only with membership. NAD found that there were sort of dark patterns where there wasn't sufficiently clear and conspicuous disclosure of the terms. The use of the pre-checked checkbox was, I think many of us who work in this area know that that kind of pre-check checkbox is disfavored by regulators, that it's, generally found to be, unfair, misleading. NAD looked at that and similarly found that this is a type of dark pattern that can be misleading. So, one of the newest cases in this area, although there's been a series of cases at NAD over the years looking at claims about loyalty programs, looking at changes and the like, looking at whether the advertising for loyalty programs and the terms and conditions actually lined up and were the same. That's a way that frequently you can get in trouble if there's a misalignment between what you're saying in your advertising and what the terms and conditions actually say. But most frequently you see litigation over this idea of a modification where there's not proper notice given, and then a change made where consumers are losing some sort of value or rights in what they've previously earned without their notice being given. Other types of laws, and we'll talk about that some more in specificity in a couple of slides. Other types of laws regulating loyalty programs, we mentioned contract, but you also see money transmission or anti-money laundering laws, particularly where cash or items of value can be earned that exceed certain amounts. That may trigger those. Can spam, TCPA, where you're collecting information and then using it for marketing purposes. Sweepstakes and contests, of course, and even tax and unclaimed property, which we'll talk about shortly. Next slide. So most notably lately, for the past year or so, there have been a couple of bills under consideration in Congress, introduced by Senators Durbin and Marshall. First, we have the Credit Card Competition Act, which really was primarily focused initially on credit card exchange fees and trying to lower those. But now that didn't pass, and there's been a huge lobbying effort. You may have even seen posters in ads or posters in even like bus shelters or the like, you may lose your loyalty programs or your loyalty points. There's been a big lobbying effort against these laws. Most recently introduced in September, there was the Protect Your Points Act, which was new legislation that would strengthen consumer protections when it came to loyalty programs by requiring greater transparency from airline frequent flyer points and loyalty programs, by giving the DOT and the CFPB explicit authority to prohibit airlines from including provisions in their loyalty program terms and conditions that reserve the right to make changes at any time without notice, require airlines to display the real-time value of 1 point per mile on every page of their website so that consumers could compare programs or point values across different programs, require airlines to show airfare and add-on pricing in dollar and points or mile values, prohibit points from expiring, and prohibit charging fees for transferring points between family members. Some of you may have heard that the DOT is currently has asked for information from the different airlines about their programs. They are investigating, looking into these programs. So there is this sort of broader investigation of how these programs work, where there may be issues from a consumer protection point of view. And so that's one thing that's going on. There's also a CFPB is also looking into this from a credit card point of view. And that's discussed on this next slide. In May, the CFPB has published a report highlighting consumer complaints about credit card rewards programs, where they identified a number of recurring issues across those complaints. Specifically, what they identified, they called bait and switch tactics, where companies were promoting their programs and rewards, but hiding what they termed as complex terms in the fine print that made it difficult to redeem rewards. The practice of devaluing rewards by raising the number of points after the fact, after people had earned them, or sort of mid earning, by raising the number of points or miles needed to redeem, difficulties in redeeming, technical glitches, customer service issues, particularly when transferring points to third-party merchants, and then revoking or losing rewards when accounts are closed or as part of expiration policies. So the CFPB has announced its intent to continue to monitor these programs and work with government partners, regulators, et cetera, to take necessary action on the issues. Of course, this has been sort of something that the current CFPB head, Chopra, has sort of spearheaded, and as we see changes in the heads of the agencies, the priorities may or may not change. It's something to keep an eye out for. But we do have also interest at the state level. So I'm going to say let's skip ahead a little bit. There's been this DOT, just to back up one, the DOT has been, regardless of what happens at the top of the agency, the DOT has implemented already a new rule that requires airlines to provide automatic cash refunds and has been working hand in hand with state attorney generals to hold the airlines accountable at a variety of levels. But the state attorneys general has been already pursuing this, and the state regulators have been pursuing state laws when it comes to loyalty programs as well. So that's something, regardless of what happens at the federal level, there is no doubt that we'll be seeing the state attorneys general pursuing these issues. In particular, there's new laws at the state level coming out of New York, regulating credit card programs. And there's also class actions and other state interests when it comes sort of from a general UDAP, unfair and deceptive trade practices point of view, when it comes to, in particular, making changes to loyalty programs, providing notice of those changes and the like, and whether those are being made in a fair and non-misleading way. So looking at this issue of notice, for many years, if you look at the terms and conditions for loyalty programs, you would see sort of this general, we have no duty to provide any notice when it came to making changes. So there are new laws now, particularly in New York, and you saw the CFPB and the DOT talking about that as well. There's this New York law that says that for credit card programs, you now have 45 days to give notice upon making sort of the decision to make a change. And then once you've announced the change, you must give program members 90 days after sort of they've been given notice before you can actually make the change. So 90 days essentially to redeem points, earn anything they need in order to be able to redeem that award or those tickets they wanted or the like. And so, this idea specifically in the credit card context, but also if you're running a program where you're partnering with a credit card, so say there's a hotel program with a credit card partner, it's something to be aware of as well. And generally I think that the trends are in favor of from a UDAP perspective, that if you're going to make a change to a program, specifically where you are devaluing the program in some way. So you're either expiring points, you are removing elite partnership tiers so they won't be able to exercise special rights, that sort of thing. You should be giving notice to members of the program so that they know that this is going to happen. And if they want to, they can sort of exercise the rights, use up their points, even leave the program before the changes are made. So in addition, when you are drafting your terms, you should be specific about, in your notice provision, how will you provide notice? Will it be posting? Will it be contacting members via email? Assuming you have emails. If you are collecting phone numbers, will you be texting them? How much notice are you going to provide? And, ideally, how will members accept the changes? Just saying company, A, we will provide notice of changes without defining the method of notice, may be too vague and may potentially result in liability if you're sued for failure to provide sufficient notice. If you are going to require acceptance, you should be thinking about how will you ask for acceptance? Will it be click to accept? Will it be continued participation in the program? Will there be some maximum period to accept? Things like that. The time when notice becomes particularly important and acceptance is if you plan to use an arbitration clause. There are cases in the loyalty and other context where arbitration has not been upheld, arbitration clauses, because of the lack of acceptance and the lack of proper notice. So that is something to consider, as well as sort of the unilateral retroactive right to amend terms of a loyalty program at any time in Texas in particular can render a contract illusory. So that is in particular, as I said, Texas. There's a case about that called National Federation of the Blind versus Container Store, where there was an attempt to modify a loyalty program, and the program, because there was this unlimited right to modify, and an arbitration clause, they refused to uphold the arbitration clause in that context. Okay, next slide. This is the New York law that I mentioned, New York Section 520E of the General Business Law. As you can see, it specifically lays out those requirements, the 90-day grace period from the date the notice is sent to redeem any points. It does specify that when the notice is required, so eliminating points, reducing the value of points, affecting the ability of the holder to accumulate points, limiting or reducing rewards availability, diminishing the value of the program overall, that sort of thing. And everybody will get this deck, so that's why we sort of load in the specifics for you. So rewards are very broadly defined to be, everything from A to Z, including travel benefits. And the current thinking is that it will apply not just to the credit card program, but to, programs that include a credit card partner. So next slide. NFT loyalty programs. We have been seeing programs that are either exclusively involve sort of the earning of NFTs, or involving, the ability to earn NFTs, which you can either redeem for something of value, or that is the item of value. Actually, I just learned last week that Starbucks, which had an NFT-based loyalty program, where the NFTs essentially acted similarly to gift cards, dropped it without much disclosure of the, wheres and whys, but the NFTs are still incorporated into the regular program, but its sort of standalone NFT-based program has been dropped. NFTs are no longer as popular as they were, say, a year ago, but they are still being used. And so it's important, to be, aware of things like NFTs can have costs. They have specific requirements, like you must have a wallet. So of course, if you're running an NFT-based loyalty program, or a program where NFTs are incorporated, it becomes very important to disclose things like the costs involved, and also think about whether, you are going to restrict the NFTs that you are awarding. Are you going to allow them to be traded? Are you going to allow them to be resold? You can incorporate into the smart contract that accompanies the NFTs restrictions on their resale, either temporarily or, long term. And whether and how you do this I mentioned anti-money laundering and the Bank Secrecy Act, but can affect sort of whether you trigger those requirements. This is very important also because the Bank Secrecy Act and anti-money laundering laws, which I'm not going to spend a lot of time on because they're extremely complicated, but it's not uncommon with, retailers or, sellers in general who are sponsoring, shall we say, loyalty programs to try to avoid anti-money laundering laws by simply staying under the money limits, the daily money limits for that trigger them because of the onerous requirements for obtaining a state license for MSBs, for money services bureaus. If you start allowing, these NFTs to be bought and sold under sort of your auspices, you can very quickly exceed value for these limits. So it's something to look carefully at if you are going to start sort of playing in the NFT space. So, you do want to look at that, or also if you're going to be issuing, a crypto-based money laundering program, not money laundering program, that would be unfortunate, a crypto-based loyalty program. So also intellectual property, what kinds of restrictions are you going to incorporate there? What are you going to offer a license versus, wholesale ownership, that sort of thing. Next slide. Gift cards. Lots going on in the gift card space as well. Of course, we have at the federal level the Card Act, which has been around since 2009. It's a federal law implemented under Regulation E, which is imposed and monitored by the Consumer Financial Protection Bureau. With gift cards, I mean, these are complex instruments. They cover everything from the gift certificates that are, issued and technically cover paper gift certificates to also store gift cards, generally use prepaid cards, and each is a different type of instrument. There are subtle differences, and it's important to pay attention to those nuances. But next slide. Typically, what the reason why sort of these become important when we're talking about a non-bank that's issuing gift cards or gift certificates is that there are federal and state law restrictions on A, whether you can expire gift cards, B, whether you can charge fees, and C, what types of disclosures you must make if you want to have expiration dates or fees. The Card Act basically says that you can't expire in less than 5 years. You can't charge more than limited fees, let's just say, and that you must disclose both of those before purchase, along with a telephone number and a website or a website, and you must disclose them, with the card clearly and conspicuously. Where it gets tricky is in the state law context, where they're all over the board, ranging from you may not expire a gift card to you may expire it, within a year, 2 years, or under a new New York law, 9 years, which is now the longest. And so to run a national program, most sellers now just say we're not expiring. The same goes for fees, runs from no fees to 1 fee, etc. And so, it really depends on whether you're going to have a uniform program nationally or whether you're going to have sort of piecemeal compliance. In the promotional context, There are key exclusions for promotional gift cards, subject to a few fairly simple to comply with restrictions. Also, merchandise credits, again, subject to certain disclosures, and then points and other types of credits. And so with promotional cards, if you disclose clearly and conspicuously that you've got what you're giving away is a promotional or loyalty card, you disclose the expiration date on the front of the card, generally in no less than 10-point font, then you should be compliant with the law. And that's helpful whether you're giving away a promotional card as part of a loyalty program, in a sweepstakes, et cetera, et cetera. Generally, fees are not an issue with promotional cards because, of course, people aren't paying in the first place. So, you know, that's not as big an issue. Occasionally there'll be a dormancy type fee charged after a long period of dormancy. Of course, you also want to provide some sort of contact information in case people have questions. Next slide. And I've already sort of jumped and started talking about this. The other big area besides expiration dates are, and am I jumping into your stuff, Jay? Because we want to let you talk.
No, you're good. I'll handle the anti-scam and the anti-fraud.
Okay. So the other big areas besides expiration dates and dormancy fees are cashback, when you have to offer sort of de minimis amounts as redemption. If a customer asks, he says, I have $5 left on the gift card I bought. Some states do require that you provide that on request. The amount that triggers that is somewhere generally between $5 and $10. And there's a lot of class action litigation over that specific requirement. So it's something to be aware of. Not every state requires this. There's a small group, and I'm trying to find what that group is. But it is, like I said, it's a big source of litigation. And so you want to be aware of this, train people at the cash register in these states on how to comply, because, for instance, Home Depot was sued in July of 2024 by the Los Angeles District Attorney, who alleged violations of the California law mandating cash redemption for gift cards with balances of less than $10. And ultimately, Home Depot agreed to settle for $750,000 and agreed to program its point of sale registers to automatically cash out gift cards with a balance of less than $10 left on it, include notice on its gift card and its website that customers can redeem when there's less than $10 left on the card, post notice at its customer service or returns area for 6 months about that, and again, provide training. Training is really important and a continuing theme in these types of settlements. Make sure that your customer service people know, the people at the registers know about their duty in the states that require this. So that's like a huge source of class actions. To back up a slide, the other really big new state law in this area is in New York, which amended its gift card just a couple of years ago to impose new requirements on its gift cards, where it eliminated most fees that could be imposed. It extended the minimum sort of validity period. You cannot have an expiration date that is shorter than 9 years. Prohibited the use of fees to devalue funds on the gift card for lack of use, and then also imposed a sort of cashback requirement when the value is less than $5. And so, typical law, other than it had added one of the new anti-scam provisions that Jay is going to talk about. So I'll turn this over to him.
Hi, everyone. Before we jump in, I'm just going to give the CLE code, which is CARD 2024, CARD 2024. So we're going to be touching on, like Melissa mentioned, these anti-scam or anti-fraud state laws. And this has been an emerging trend among the states. This has been an ongoing concern for a while at the federal level and the state level. The Federal Trade Commission issued a report recently about the massive amount of fraud attempts that are ongoing, that are especially prevalent during the holiday times. Just for time's sake, I'm going to go through these fairly quickly, but we will be circulating the slides. But I did want to highlight kind of the concerted, coordinated government effort. This year, the Department of Homeland Security kind of initiated what they called Project Red Hook, which was a coordinated government effort to investigate and prosecute a fairly sophisticated and coordinated criminal enterprise where consumers were victims of various types of fraud attempts. So I'm sure a lot of you have kind of been seeing this on the news, the card tampering, online attacks, victim-assisted fraud. And here it was quite serious and kind of took a lot of government efforts to prosecute. But I'm going to be going into the state laws that we've seen. Most recently was Delaware, and this was enacted in September of this year, so very recent. The Delaware law is a notice provision, and it requires sellers of gift cards to display a conspicuous notice where the gift card is physically displayed or near the physical location where the sale occurs. I did want to note that Delaware defines a gift card in a very similar manner as the Federal Card Act. And a lot of states do take this route, but if you are operating at a national level, like Melissa mentioned, you will really want to pay attention to the state definitions because they can vary. For example, here, Delaware, the fourth kind of bullet point is saying that a gift card in this context is one that's honored at a third-party location. So this will be applying to sellers selling third-party gift cards as opposed to a retailer perhaps selling its own gift card. Next, we have New York, of course, as Melissa mentioned. New York requires, again, gift card sellers to display a conspicuous notice at or near the physical location where the card itself is displayed or at the point of sale. New York went further in promulgating a kind of model notice that sellers can use to comply with the law. It's not required that you use this exact notice, but this notice does incorporate kind of the two pieces of information that the law requires so that the company is cautioning the purchaser about prepaid card scams and instruct the purchaser what to do if they believe they're a suspect, if they suspect that they're a victim of a potential fraud. And as I mentioned, there's ongoing interest in these gift card laws that they tend to be bipartisan and don't get much pushback. So this year we saw Senate Bill 9900. This would impose various packaging requirements, additional training requirements for employees, and record-keeping requirements as well. I'll be talking about Maryland in a bit, which did actually enact a law that had many of these requirements. New Jersey has been another state that has been pretty active in attempting to combat fraud and scam attempts. They, again, require training for employees on how to identify and respond to gift card fraud. This statute actually incorporates a civil penalty for failure to comply. And again, the legislature is looking to expand these types of laws. This year we saw Assembly Bill 4636, which would have the notice requirements similar to Delaware and New York, and instructing purchasers on the potential fraud or scam attempts that might be occurring. Rhode Island, once again, has a very similar notice requirement. They have their own model notice that can be used. The statute here does say in a form prescribed by the Department of Business Regulation that, again, should be displayed where the cards are displayed or at the point of purchase, cautioning the consumer again about those two pieces of information. So Maryland is the state that was getting the most attention this year, given the breadth of the bill. It was signed into law in May of this year. It establishes numerous rules and procedures that merchants have to follow when they're selling open loop or closed loop gift cards. And I don't think we've teased out the differences yet. So very briefly, open loop cards these are the ones you'll see, the Visa, the MasterCard kind of gift cards that are redeemable at multiple sellers or merchants. And the closed loop gift cards, these are the ones that are more specific for a certain retailer or seller. Maryland also has a notice requirement very similar to the states that I've just been mentioning. One thing I did want to call your attention to is that Maryland, in addition to kind of the physical notices that have to be posted, this statute says that it also needs to be displayed on the web page where the gift card is offered for sale. So and that has to be displayed immediately before the sale is finalized. So that is something that is new and different. I also wanted to mention that there are different effective dates. So for the open loop gift card provisions, these will take effect on June 1st of 2025. And then for the closed loop gift card, these will take effect in October 1st of 2025. Maryland was also getting a lot of attention because they have fairly strict and specific packaging requirements. I won't read them off to you here, but essentially they're meant to kind of hinder or prevent someone from coming in and tampering with the card. And so when a consumer buys it, they don't, they're not buying like an empty or drained gift card. There are exemptions from the law, specifically for the packaging requirements. For example, if the gift card is kind of stored in an area in the store where only an employee can reach it, or if the card uses a chip instead of numbers and it's only activated by the consumer after registering the card on the issuer's website. There's training requirements, very similar, training for employees about attempts, fraud attempts, scam attempts. There's record keeping requirements for third parties. There's no private right of action for this law, but there are hefty fines that can accrue, and for repeat violators, they are especially heavy. So with that, I'm going to turn it back to Melissa to talk about unclaimed property and a sheet.
Right. So gift cards have sort of, I know everybody loves unclaimed property law, or some people here are going, huh? But gift cards have a sort of special place in the unclaimed property pantheon. Street law, as you may know, provides that property may be presumed abandoned if there is no activity with respect to the property for a specified period of time. So this applies to gift cards in the sense that, people put gift cards in their drawer and they forget them. And, they may or may not find them after a year or 2 or 10. But for the companies that issue them, it becomes an accounting problem where they have huge chunks of funds that are allocated to these gift cards, and they're just sitting there on the books. So what do they do about them? Well, with respect to, state law and this funny little unclaimed property doctrine, which comes from, English common law, essentially the state law says, well, we really think we're the better custodian for these gift cards. Companies go out of business, et cetera, et cetera. So depending on the state, the law may say either after some period of time, whether it's 3 years or 5 years, you must take all of these unclaimed gift cards, tote them up, and report them to us, or they may exclude or exempt gift cards from unclaimed property laws. And you've got sort of a list of what some states do, whether it's exclude all gift cards, exempt certain types of gift cards, like gift cards issued for food or products, merchandise points, loyalty cards, like the promotional or loyalty cards we mentioned before, and then some as sort of a means of incentivizing companies not to expire their cards, have said only gift cards that expire should be eschewable. So essentially, a lot of companies have done things like to take advantage of the fact that some states exclude or exempt them, have actually incorporated gift card subsidiaries in states that exempt the gift cards, because there is a priority rules established by the Supreme Court that say essentially, well, in trying to figure out which, state should have the right to these unredeemed gift cards, we look first to the state of that issued the gift card. Actually, wait, I've got it wrong. We look first to the state of residence of the owner or the purchaser of the gift card. So if I buy a gift card, we might look, if that's the only name or address you have in the records, you'd look, hey, Washington, D.C., what do they do? Oh, wait, they exempt, and I'm not saying they do, this is my example, they exempt the gift cards. So if that either DC exempts gift cards or you don't have my name or address, you then look to the state of the incorporation of either the gift card subsidiary or the company that issued the gift card if you don't have a subsidiary like that. And so if that state also exempts the gift cards, yay, you get to keep all of those unused gift cards, which is a nice situation. But if that's not the case, you then have to report all those gift cards. So this is a fun exercise. But it's a complicated one, and it depends on if you actually have kept, in part, the name and address of owners or purchasers. There's a lot of case law over all of this, and in particular, there's a bunch of cases over a situation where a company claimed that they could actually sort of take your gift cards and hide the name and address of the purchasers. This was not the case, and the courts found that, and it was kind of a mess. So you need to proceed with care here, because that company ended up paying, or these companies ended up paying, a whole lot of money in those cases. So an example of one of those companies is H&M, who used this company, card compliant. In that case, the New York Attorney General alleged H&M withheld unused balances on gift cards that should have been transferred to New York's Office of Unclaimed Property or unclaimed funds in that case. So they ended up instead paying $36 million in a settlement. In another similar case, Delaware XREL French versus Card Compliant, there was actually a sort of a number of private attorney general suits where French ended up suing and collecting a nice sum as well. But again and again, these companies had to pay over this information or this money that they had tried to avoid escheat. So be very careful when it comes to escheat and whether you need to escheat. Often it ends up being sort of a patchwork as to whether you can avoid in certain states or not. Next slide. Do loyalty points escheat? Some states do include a broad exemption for escheat for loyalty cards. They may require escheat if there was any consideration or purchase pay when it comes to promotional or loyalty cards or points. It's difficult. There's something called the derivative rights doctrine, which says the state sort of steps into the shoes of the owner of the points or the gift card or whatever it is. So in this sort of situation, the owner of loyalty points or a loyalty card has the right to demand products or services in exchange for reward points, but not cash in most cases. So the holder has no obligation to pay that owner a cash equivalent just to exchange products. So if you look at this derivative rights, does the state get cash? No, just this product or service. So in a situation where there's no express exemption for points or loyalty cards, you may need to rely on the derivative rights doctrine. But it's not always, it hasn't always clearly been upheld in every state. So still a lack of clarity in many states as to whether loyalty points will escheat, but good arguments that they shouldn't. Next slide. And privacy.
Yes. Thanks so much, Melissa. So I'm just going to spend the last few minutes talking about a very important consideration for businesses that are rolling out loyalty programs, which is the state comprehensive privacy law landscape. So there are close to, I think actually over 20 states now that have enacted state privacy laws across the U.S. We expect that the number is just going to continue to grow, over the course of the next year. And these laws have a really important sort of introduce important considerations for loyalty programs. And we're going to talk about two laws in particular that have detailed loyalty program requirements and also have seen a bit of enforcement activity associated with them. So the first law is the CCPA, the California Consumer Privacy Act, which I'm sure folks are familiar with. The CCPA regulates financial incentives. So that includes not just sort of your traditional loyalty programs, discount club programs, other sorts of programs where you're making qualifying purchases and getting a kind of a discount in the price or service. But the term actually could potentially extend broader. And the California AG has kind of made comments just talking about even receiving free items or discounts sort of apart from a loyalty program. So a structured loyalty program could constitute a financial incentive that triggers the requirements under the law. The second state is Colorado, which also has detailed loyalty program requirements. In that state, the term that the statute uses is bona fide loyalty programs, and it's has been interpreted to be a little bit narrower than the CCPA's financial incentives. So I think this law is kind of has been interpreted more as kind of squarely focused on more structured loyalty programs. Although there's been less enforcement under the under the CPA than the CCPA, and so I think time will kind of tell just in terms of how broad a regulator may sort of take that definition to be. So I think the main thing that as we're kind of just in the close here, that I want folks to leave with these laws is that the CCPA requires consent, opt-in consent to have an individual participating in a loyalty program. This has kind of complicated and sort of nuanced implications for the loyalty program sort of requirements that Melissa was talking about earlier. And so we find ourselves kind of frequently helping clients navigate the dynamic between this opt-in consent requirement under the CCPA, as well as kind of different loyalty notice and consent and other loyalty program requirements that that exist under other state laws. One thing I'll just mention, one last thing I'll mention in connection with the prior side was just that the Colorado Privacy Act requires voluntary participation of the consumer. It doesn't have an express consent requirement, but a lot of businesses, right, are looking to sort of for a one-size-fits-all approach to a nationwide loyalty program, and complying with California's opt-in consent requirement would suffice for the Colorado requirement. So that's just something to keep in mind, just regarding the interplay between those two laws. I'm not going to belabor these points just given the time, but basically both the CCPA and the Colorado law have detailed notice requirements in connection with the consent. So these need to be at the point of registration for the loyalty program, either just on the page, or there can be a link to the privacy policy that includes the relevant terms. And then it looks like we're just at about time. So if you want to, Jay, kind of skip to sort of our takeaways here, I can kind of just close up. So yeah, again, auto enrollment for loyalty programs is not permitted in California. There needs to be opt-in consent from the consumer. Also, one other thing to mention is that even leaving aside the sort of loyalty program specific requirements, any processing of sensitive data in connection with the loyalty program would independently require opt-in consent in certain instances, and there can be other sort of compliance requirements that apply if you're handling sensitive data as part of a loyalty program. The California law, unlike Colorado and a lot of the other state laws, does regulate employee data and business-to-business data. So that can introduce a lot of complicated considerations if there are sort of employee incentives or discount programs that may be offered in California. And then the last thing I would just mention is that these state laws do offer other consumer rights, right to access, right to delete, opt out of sales. And there's sort of a complicated interplay between the loyalty program, opt-in consent, and other requirements, and the obligations to offer those rights to consumers. And so that's something that we often help clients, navigate as they're rolling out loyalty programs and balancing those obligations with the obligations that they otherwise have under these laws. And this is an area, especially in California, the California AG has been enforcing against businesses, has sent notices of alleged violations within the last 2 years to businesses that have been allegedly non-compliant with the loyalty program requirements. So this is an area that we've seen regulator enforcement, and we expect that sort of focus will likely continue on into 2025.
Okay, do we need to give a code for anybody who can't stay over again, or are we just the same code?
It's the same code, but I'll just remind everyone it's CARD 2024, CARD 2024.
Just to wrap up, this is obviously an area that is very active. We do work as well on, multi-country promotions, increasingly, and we find that, while I think the US is probably the most active, out of most of the countries, Canada is very active as well now. when it comes to regulating programs. And even in countries that maybe don't have as many specific regulations, when it comes to loyalty programs, well, certainly there are lots and lots of regulations everywhere when it comes to gift cards. And, you've always got those UDAP, general consumer protection, dark patterns, disclosures type of regulations in the background saying you can't just take away, earned things of value without, disclosures, notice, etc. Whenever you're thinking about these types of promotional programs, loyalty, gift card, related programs like sweepstakes and contests and commercial co-ventures, also you need to think about what platform are we talking about? How are you making the disclosures so that they're clear and conspicuous? Where are you posting the terms and conditions? And how are you linking? It's no good to bury terms and conditions on a website. We were just working with a program where, sure, the terms and conditions were posted, but then, they were on sort of one page and then there was a link via the help page. You couldn't find them anywhere. So it's important to be able to find the web page. And in addition, if you've got sign up via brick and mortar store, how are you going to communicate and get consent to terms, in brick and mortar? The program may be very different if it's strictly promotional versus now increasingly we're seeing programs where maybe there's a fee to participate and the considerations can be very different and difficult perhaps there, like we saw with the NAD case we talked about in the very beginning where there was a $9.99 per month fee, and then now you've triggered the subscription rules and the like. So that's another one. And then of course, are you being consistent with the terms, with the advertising? What information are you collecting and who are you sharing it with? And contractually, are your agreements aligned with the terms and conditions of your program? Are you securing all the necessary permissions and rights if you are going to be using other logos for third parties? And of course, whenever you're drafting terms for a new program, it's always key to be preparing for the sort of inevitability of modification and change, because that's gonna happen. Finally, just be constantly keeping your eye on new technologies, how the law is developing when it comes to things like digital consent, virtual currencies, charitable promotions and CCVs, because these are constantly promotions are adopting these new technologies. And so it's important to keep track of, the new technologies because, your business people are going to come and want to adopt them into your programs. So that's that. We're available for questions. And of course, feel free to email us and follow up. Thanks very much. I think I answered every question but one, which is unusual. Okay. Thank you, everyone.